Let's go out to Randy Kessler, joining us out of the Atlanta jurisdiction. Randy, you don't have to wait till the court reporter does a formal transcript for a readback. Haven't you ever seen the court reporter read his or her tape? Nobody else can read it. I hope they're telling the truth. But you don't have to wait till they put it in the King's English.
That's true.
Absolutely not. You're right. Even in the middle of trial, if you can't remember the question or the judge wants the question read back, the court reporter pulls it up, reads it right then and there. It's like, it's Greek to me and you, but the court reporters go to school for a long time to interpret that kind of stuff.
Exactly, and the good thing about that, I wish you guys could see it. The court reporter's paper that she types on, unlike being an 11 by 8 like this, it looks like a receipt from a store. It's about that, you know, about 2 inches thick, and it's really, really long, and that's what they read when they do a readback in front of the jury. Let's go out back to Randy Kessler, family attorney in Atlanta, Georgia. Joint venture. Some jurisdictions call it party to a crime. Explain the theory of joint venture.
Well, you know, either somebody was doing it with them or he acted alone. Can I also comment on the read back to the jury that you were just talking about, Nancy?
Yeah.
Well, you were talking about the judge calling the jury back in to tell them a specific charge without reading the entire charge, the 70 pages worth of law that he read to them the first time. When you call a jury out of their private caucus and start talking to them about one area of the law, I think sometimes that gives undue emphasis to that area. And if I was a layperson and I was not a lawyer and I was on the jury, I'd go back and think, why did the judge talk to me about that? Did he think that he needed to emphasize that? You know, jurors give a lot of weight to everything that comes out of the judge's mouth. Judges are noble. They're the supreme person in the courtroom. They've got the most wisdom, and they are the word of the law. And when they tell the jury, you need to think about specific intent. Could he have been under the influence of alcohol or some other substance that maybe diminished his intent? That, I think, is going to affect their deliberations. How much, we won't know until after the trial's over.
Good point. Out to Randy Kessler, veteran trial lawyer out of the Atlanta jurisdiction. Randy, thank you for being with us. At this juncture, the jury is in their 3rd day of deliberations. I don't recall ever having a jury out that long. Have you?
We've had them out for 24 hours, but by the 24th hour, usually someone comes up with a smart idea, like putting a box of pizza next to the jury door so they smell it, get hungry, and want to go home.
Wait a minute. Wait a minute.
All right.
I said 3 days. You said
No.
24 hours. Does that mean your jury deliberated 8 hours a day? Or how did that break down?
It broke down. We finished the case about 3 in the afternoon, and by the end of the 2nd day, they came out with a verdict. It was Friday, 5 o'clock, and that was it. They were going home. They came up with a verdict. So I've never had one go more than a day and a half. Okay,
well, you know, that's the Friday afternoon cure. I wish you had told me that at the very beginning, and I would have said Friday, 4:58, verdict. Why is that always true? It's almost a joke, but the reality is it's true.
Well, you know, Nancy, what I seem to find is that when you go back to the jury room, what I hear from jurors, and we talk to jurors after the trial, which is where we get our best information and makes us better lawyers, is that everybody opens their mouths and they're about to say, didn't you hear the same case I did? And you have 12 jurors and they heard 12 different cases and 12 different stories. And it's a process of elimination. You've got an extremist on the left who says there's no question he did it, an extremist on the right that said no question he didn't do it, and they compromise down, and that compromise takes a long time. You know, some people hold on to their beliefs, and it may be one holdout juror, and 11 feel one way, and that last juror causes it to go a day, 2 days, 3 days.
One juror, and I have seen that happen many times, as a matter of fact. And Randy, another question I want to ask you is, I find this very disturbing, and in my mind, it shows a lack of understanding of the criminal justice system. When people believe, for instance, in this case, that there's not a motive for McCowan to do this deed. I have had so many rapes and murders where what's the motive for rape? Sexual predator. There is no motive that a reasonable mind could understand, and I have had murders over less than a $10 drug debt. So the motive really, sometimes you don't have a reasonable motive. I don't think there is a reasonable motive for murder.
Well, that's a problem when you try to substitute your rational mind for the mind of an irrational person, someone who's been convicted of previous crimes, someone who's a lifelong criminal. Why would somebody do something? I don't know. And that sort of goes to the point of, is he mentally retarded? Is he smarter than the average person?
There you go.
You know, I'll tell you what, I don't really buy into the whole defense of he wasn't that smart, because the truth of the matter is, what smart person would commit a rape and what smart person would, it would take somebody, I would think, fairly stupid to say, I committed a rape and now I'm going to cover it up by murdering the person, because rape might carry a long sentence.
Randy, think about it though. Remember Ted Bundy? He scored off
Sure.
the charts on a lot of his IQ and psychological testing. So I don't think that
I agree with you.
IQ really, a lot of, I've had millionaires commit murders that are
I agree with you.
incredibly brilliant intellectually, but still commit murder. So I don't know that IQ has anything to do with crime.
I agree with you. And they're arguing that he was dumb and that's why he didn't do this.
Yeah.
If he was dumb, then he wouldn't have committed a murder. If he was dumb, he would have ran and ran and ran. He's smart. He's smart enough to answer those questions. Those are questions that a lot of people on the street would never know the answers to. I don't buy that defense.
Joining us, oh, go ahead.
I'll tell you something else. They're focusing a lot on the damage and the emotional trauma to this child, and I think that's a very clever strategy. There is no smoking gun, and that may be the fatal flaw in the case. And I think they're substituting the smoking gun with the images, the dramatic images of this little child, crawling around on her dead mother. Those are images. It's an emotional case. If we weren't human beings, if we didn't have emotions guiding us, we'd plug the facts into a computer and spit out guilty or not guilty. They've got to focus on the emotional trauma and damage to this child to get the jury to dislike whoever did it. And there's one person in the room that they want them to believe did it. That anger has to be directed towards McGowan to get a guilty verdict.
Well put. Veteran Atlanta attorney Randy Kessler joining us. Randy, walk slow and hurry back. Thank you for being with us. Everyone, we'll all be right back. We are in a verdict watch here at Court TV. Please stay with us.